Hello everyone. So this is going to be a lecture about the Crown prerogative, or the royal prerogative as we usually say. So a prerogative is something that's both a right and a duty. So it is nominally held by the sovereign, but exercised on her behalf by the Prime Minister, because of course the sovereign always acts on the advice of the Prime Minister, and has done so for, well over 100 years. Queen Victoria occasionally disagreed with things, did virtually everything was asked of her, and didn't speak out against policies that she disliked. It goes back in some sense at least 300 years. You know, Queen Anne was just disagreed with just a very few things, really, to 1688. Prior to 1688, you know, monarchs who would go dead against the will of Parliament and their ministers. Anyway, so the royal prerogative, in effect, gives the Prime Minister very extensive powers, can do things by fiat, and the Queen will just sign whatever's put in front of her. So now courts can adjudicate on prerogative power, not that they can't say that it doesn't exist, but they can adjudicate the limits of it on the exercise of prerogative power. Notably, there's a case about General Communications Headquarters when this came up. GCHQ, which is in Western England, is really like listening and intercepting emails and so on. That's the UK's spying division on communications. And there was the case there about the restrictions that were to be imposed on the people who worked there by royal prerogative. So it's recognised as being a key part of common law. Let's turn our minds to Sir William Blackstone, that celebrated 18th century jurist, author of the Commentaries on the Law of England, perhaps the first authoritative study of English law. Anyway, and he said that special preeminence which the king hath over and above all other persons, those rights and capabilities which the king enjoys alone. Right, that was Blackstone's definition of the royal prerogative. Now coming on to another illustrious scholar of jurisprudence, that's Albert Venn Dicey, as you may know, the Vinerian professor of public law in the University of Oxford in the early 20th century. And this is how he described the royal prerogative, saying, the residue of discretionary or arbitrary authority, which at any time is legally left in the hands of the Crown, which every act which the executive government can do without the authority of Parliament. All right, so we've perhaps got a clearer idea of what it is. So it developed down the centuries, as I said. 1688 was a revolution, the Glorious Revolution, some people call it, and step by step, power passed from the monarch to Parliament and ministers. These ministers which are nominally appointed by the monarch. Well, there was a famous case of BBC and Johns, a 1965 case, and it was held by Lord Justice Diplock that 350 years in a civil war too late for the Queen's courts to broaden the prerogative, so they couldn't just give you more prerogative, and so Lord Diplock was contending that the English Civil War in the 1640s were about the Crown abusing its power and trying to expand it too much. So the different kinds of royal prerogative. The Crown has got some legal prerogatives. The monarch has her own personal constitutional powers, and indeed there are executive powers to order things to be done or indeed not to be done. Okay, so what are these? Well, the legal ones, there's the Crown Proceedings Act of 1947 sets out some of these, and you may know the important Scots case of Lord Advocate and Dumbarton. That's in 1989. There are also personal ones, but these have been limited somewhat by convention about various appointments. Loads of people, judges, Anglican bishops, archbishops, army officers, they're all appointed by her. But really, she doesn't know or care who's there in the army, except for very few top people, because they appoint the people below her. And army officers, when they're kind of commissioned, they get something which is from her nominally, but she doesn't actually sign it in most cases. I can't remember who was saying it in the early 19th century that Queen Victoria, when she was 18, she had theoretically the power to dissolve the army, the navy, the civil service, everything. All right, so let's look at some of these executive powers. So as I say, she appoints cabinet ministers, she appoints ministers of state, ambassadors, high commissioners, and so forth, not just in the United Kingdom, in the 15 other Commonwealth realms, you know, Canada, the Solomon Islands, Vanuatu, New Zealand, Australia, St. Lucia, Jamaica, Barbados, the Bahamas, Belize, and so forth. She's got the royal prerogative of mercy, to reduce sentences, to let people out early. It used to be relating to capital punishment. Obviously, that's not around anymore. There are various honours which are conferred by her: OBE, KBE, Order of Merit, all the rest of them, Victoria Cross. Making someone a dame or a knight, a peer, a peeress. Collecting revenues is Her Majesty's Revenue Customs. Issuing passports, they're in the name of Her Britannic Majesty. Signing treaties and so forth. And, of course, the defence of the kingdom or the realm. Now, there are certain limitations placed on these prerogatives. Remember the separation of powers. We have the rule of law, and so nobody's above that, not even the monarch. So parliamentary sovereignty is laid down by statute, and Parliament can change anything. Could presumably take away the crown prerogative. Now, be unlikely they take away all of it, but take away parts of it. So there is a complex relationship between statute and prerogative power. It's almost imponderable. So her power is constrained. It's not voluntas rex lex suprema est. The will of the king is the supreme law. It's not the case with that. So, so let's look at an important case about this, which touches on a key statute here. There was Attorney General and De Quista's Royal Hotel, 1920. In this case, it decided they had to sort out whether statute or prerogative took precedence. So Lord Atkinson, who was a judge sitting on this case, he said that the statute abridged the royal prerogative, as that means limited it. And certain prerogatives were in abeyance. If they weren't exercised for a very long time, they were held to no longer exist. So use it or lose it. So we'll see how the prerogative interacts with Parliament. So many people say that Parliament has democratic legitimacy, the royal prerogative does not. There was a well-known case about this, Laker Airways and the Department of Trade in 1977. There was the Bermuda Agreement and the Civil Aviation Act about 1971. Now, so this Act of Parliament clashed with the royal prerogative. So what was to be the outcome of that? Well, you'll have to look it up. It's very instructive. You should see the ratio decidendi. So Parliament and the prerogative. There was a notable case in 1995, and the Home Secretary ex parte Fire Brigades Union. The Home Secretary at the time was a Conservative, Michael Howard, later leader of the Conservative Party, and he didn't want Parliament to have any say about this criminal injuries compensation scheme, and the Fire Brigades Union saying, well, this is not fair because we won't be adequately compensated, especially if we're injured when we're putting out fires, particularly if they're caused by arson, because the criminal has started the fire, we have to go and put it out, and we suffer, we're victims of crime, therefore we should get plenty of assistment for that. But he was saying, no, there's nothing to do with Parliament. Using the royal prerogative, I'm going to advise Her Majesty to do this or that, as in to reduce the amount of compensation they want. They're not happy about it. So, did Howard win? As in, was Parliament to have that in its purview or not? You have to find out. Anyway, so there has been a seminal case quite recently, actually, when Gina Miller, this anti-Brexit campaigner, she brought a case to the Supreme Court, saying that they couldn't go ahead with Brexit because they hadn't followed proper procedure, and they were abusing royal prerogative. So this case is called R. Miller and Secretary of State for Exiting the European Union, 2017. Because she was bringing out a suit against that cabinet minister. So the R as in Regina, and it was on the part of Miller, Gina Miller. So Lord Neuberger in the House of Lords, he was one of the Constitution, as in that group of judges who heard the case, and he had the following to say about it. It would be inconsistent with the long-standing and fundamental principle for such a far-reaching change to the UK constitutional arrangements to be brought about by ministerial decision or ministerial action alone, all the more so when the source in question was brought into existence by Parliament through primary legislation, which gave that source an overriding supremacy in the hierarchy of domestic laws. So it was ruled that the government simply couldn't use the Crown prerogative to get out of the European Union. There had to be a parliamentary procedure. Now, I know some of the Eurosceptics were saying, well, excuse me, we already had parliamentary procedure. We had the European withdrawal, so we had the Referendum Act, we had the European Notice of Withdrawal Act in 2017, eventually the European Withdrawal Act, and even things about this referendum was held pursuant to the Treaty of Lisbon and the Article 55 notice. That was partly because well, the Parliament had ratified the Treaty of Lisbon, which allowed all member states the right to leave the European Union. Now, prior to that, it was arguable whether member states had the right to secede or not, but after the Treaty of Lisbon, it wasn't. It was in black and white, and the treaty is absolutely explicit. It was crystal clear on this point that every member state had the right to leave the European Union at any point for any reason, with or without a referendum. Anyway, so as the government had assured people in 1973 that membership of the European Union, or EEC as it then was, depended on the continuing assent of Parliament, that assent was withdrawn. All right, so the use of the Crown prerogative can be subject to judicial review. So the courts have jurisdiction over the extent of this prerogative, but not over its existence. And nobody disputes it exists. But this has gone as far back as the case of proclamations in 1611, or De Cases Hotel 1920, which I mentioned, or indeed Burma Oil and Lord Advocate, a case from 1965. Okay, so the courts are somewhat constraining the usage of the royal prerogative. Some people say it's a medieval farce, it's an anachronism, it's had its day, and it puts too much power in the hands of government ministers, because despite being crown prerogative or royal prerogative, we all know that in reality it's actually government ministers get to use it. So courts are looking more closely at the use thereof. There was R and CICB ex parte Lane 1967, or Gourier and Union of Post Office Workers 1978, to do with strikes. Remember, apartheid existed in South Africa back then, and so there were racist policies were pursued by the government there, and so many people wanted sanctions. No trade with South Africa would collapse the apartheid system, and did postal workers have the right to refuse to send things to South Africa or to receive things? I'm not sorting that mail, but this is the royal mail. Royal prerogative says that you must. Anyway, so the judicial review is about how royal prerogative is exercised. As I said, there was the GCHQ case, which was a leading case here. Now, this was a turning point. There was Council of Civil Service Unions and the Minister of the Civil Service, 1985, saying that these people are not allowed to, in the GCHQ, join trades unions because they might go on strike or they might just get too uppity, and this is so critical to national security it can't be permitted. Now, Tony Blair, a young Labour MP, said it was scandalous and undemocratic that this was the case, or that these people have no right to strike. George Galloway, Labour MP, said it was tantamount to slavery, which is obviously the height of absurdity. You might disagree with the decision, saying that they can't join trades unions, but let's go easy on the hyperbole here. Anyway, so what was the government's argument of this? It said that they could exercise prerogative power, and that it was not justiciable, as in to say it was not subject to judicial review. And then they said, however, if you reject our first argument, okay, we've got another echelon we can fall back on, and that is that there's such a thing as legitimate expectation, and as in to provide excellent national security communications, intercepts of what a potential enemy is saying, or a real enemy is saying, is a hot war. And there's a legitimate expectation to provide this information to the Army, the Air Force, the Royal Navy, all the rest of it. That would be frustrated, as in made impossible, if the people at GCHQ were in trades unions or going on strike and things like that. Okay, so we'll look at this argument a bit more. So the review was not decided by the type of power. So it's decided by the kind of power they have and not the source of that power. This is what Lord Roskill had to say in consideration of this point. He said that there's a logical reason why, there is no logical reason why the fact that the source of power is a prerogative and not the statute should today deprive the citizen of that right of challenge to the manner of its exercise. In neither case, the act in question is an act of the executive. To talk of it as an act as an act of the sovereign savours of the archaism of past centuries. So Lord Roskill, he rejected that argument, the idea that it's not subject to judicial review. He said it most definitely is subject to judicial review. It would be antique to say that you can't question what the monarch's doing. Well, let's go on to the second argument that was advanced by the council for the government. By the government, obviously not talking about the monarch really, the elected government. It was a conservative government in office back then. I said that in the end, it was not against the law to have frustrated a legitimate expectation. Therefore, they said that using prerogative power had involved matters of national security, and these were political issues, not judicial issues, and they had to be determined by the executive. It'd be wrong for the court to do so, because we've all had the different spheres, and the judges, they can't stray into the political arena. Just to be wrong for the executive to trespass into the judicial arena. Anyway, so certain things are non-justiciable, Roskill said in his Obiter Dicta, as in, it's not as a ratio decidendi, it's other remarks he said around this. So certain issues cannot be brought before the courts, are not subject to judicial review. Amongst them are defence of the realm, signing and ratifying treaties, mercy, as in, are we going to reduce this sentence, let the person out early? That's royal prerogative. The court will say, no, you can't let the person out early. The appointment of ministers and dissolving Parliament for the sake of elections. Remember, there's a Fixed Term Parliament Act 2011, but by a 2/3 majority, the House of Commons can call an early election. They've done it twice since then. Or indeed conferring honours, OBE, VC, Military Medal, Distinguished Service Order, KBE, or KCB, and all the rest of it. That's in the gift of the Crown, usually on the advice of the Prime Minister, to appoint or not appoint to people to these various honours. Okay, so anyway, after that 1985 case, it seems that judicial review has extended a little bit. In the case of mercy, there was R. and Secretary of State for the Home Department ex parte Bentley, 1993, about Derek Bentley, who was executed in about 1954. You may have seen the film Let Him Have It. Bentley was a juvenile delinquent, although actually he was 19 by the time this happened. Who'd been in prison, but he was mentally subnormal. He was involved in a robbery in which someone was shot dead. Bentley didn't shoot the person. He was already under arrest by the time that the police officer was shot dead. But nevertheless, Bentley was an adult. There was where his accomplice was 16, was a minor, and there was a law of common purpose. If you embark on a criminal enterprise, as a result of which murder is committed, then you are guilty of murder in consequence of being a party to that criminal enterprise. So it's called common purpose, or in the United States, the law of parties. Therefore, he would swing for it. Bentley was hanged for that, whereas his accomplice, being legally a child, was not. And was he wrongfully convicted, Derek Bentley? At that time, they decided that no, he wasn't. Or could they give him a posthumous pardon? No, they wouldn't. Anyway, or there's another important case about passports. R. and Secretary of State for Foreign Affairs ex parte Everett. So certain things which previously wouldn't have been regarded as within the purview of the courts came within the purview of the courts. Previously, people would have said that's royal prerogative, back off, judiciary. Okay, so the review is becoming more intense and arguably intrusive. There was a milestone case, which is R. and Secretary of State for Foreign Affairs ex parte Abbasi, 2002. This was a British citizen who was arrested by the United States in Afghanistan and who had put in a jumpsuit, taken to Guantanamo Bay, Cuba. Why there? Because it is legally part of Cuba, even though the United States claims to have a lease on it, and therefore they're outside American laws. They're not in the United States, so therefore they don't get some of the legal protections they would get if they were in the United States. So some of these British citizens said, it's appalling, the Foreign Commonwealth Office not doing us enough to have us let out. We're held here without charge or trial. We've got no day in court, no hearing, no possibility of being released. This is effectively a life sentence without a charge, without knowing what the accusations, a chance to challenge it. This is grossly unfair. We've been deprived of our habeas corpus rights, and the UK government should do everything to get its ally, the United States, to set us at liberty. So is about legitimate expectation. Did these British citizens have a legitimate expectation that the government would move might and main to have them freed, or at very least put them on trial? And so the representations made by the Foreign Commonwealth Office, were they sufficient? And that's what the courts were looking into. Now, some people say agree or disagree with the government's policy. It was kind of quite meek towards George W. Bush's administration, but some people say this is a matter of diplomacy and government policy, how you handle that, and that's not for the courts to decide whether the UK government's going to play hardball or not. Otherwise, we might as well have the judges just formulate and indeed exercise foreign policy, and they don't have to live with the realities, and they're not foreign policy experts. Okay, so there are other issues when things are arguably political questions, and the courts have looked into them. There was and Secretary of State for Foreign Affairs ex parte Rees-Mogg in 1994. So Lord Rees-Mogg is the father of the Conservative MP Jacob Rees-Mogg. He took out a lawsuit against the government on the side of the Maastricht Treaty. That was ratified in 1993, and he said this was wrong. This is a treaty which created the European Union. Prior to that point, with the European Economic Community, EEC, and Maastricht turned it into the EU. It's the Treaty on European Union, as it's officially known. But he said that was illegal. Anyway, so the court said, no, it's not, that the government is allowed to do this. But perhaps it was wrong for the court to even hear the case, say we're not competent, that's not within our scope. Or there's another case, Bancourt and Secretary of State for Foreign Affairs 2008, about Diego Garcia. Diego Garcia is an island in the Indian Ocean which has been British rule since the late 18th century. And in about 1970, it was given to, it was late 60s, Harold Wilson's Labour government leased the United States for a very, very long time, and the people from these islands, the Chagossians they're called, were all removed and put in Mauritius, and they'd not been allowed back for about 50 years, not even to visit the graves of their ancestors. And there are lots of islands because they not live on one of them. They feel they've been treated appallingly, weren't treated very well by Mauritius for quite a long time, and they wanted to legally challenge this situation. Their rights had been abused. They'd not been properly compensated. But anyway, it was all under the Crown prerogative that Wilson said, okay, that the United States, you can just use this for, I think it was 99 years. So some people say that that was illegal and it should have gone through Parliament or so on. But this was within the Crown prerogative, so they were allowed to do it. You might think it's unfair, but it is within the Crown prerogative. It was decided in the end. Okay, so this system might be about to change. Might be about to royal prerogative might be about to be reduced. So some people, like the late Tony Benn, the ultra left-wing Labour multimillionaire MP, formerly Viscount Stansgate, he was dead against it, and he said it's a sort of an element of dictatorship in our constitution. So the Constitutional Reform and Governance Act 2010 changed things, put the civil service on a statutory footing, previously done about royal prerogative to be appointed here and there, promoted, demoted, and said that a ratification of treaties, it must go through Parliament. It can't simply be signed. This is not legally binding until it's ratified. They almost always were ratified before that anyway. Or the Fixed Terms Parliament Act, saying we can no longer be using the Crown prerogative for a Prime Minister to call an election at a time which is advantageous to his party. You can prime the pump for the economy right before an election, or do a tax cut or right after a war, and that gives an excessive advantage to the incumbent. But as we know, by a vote of 2/3, you can dissolve it early anyway. So that took away the prerogative power of the Prime Minister to call the election at a moment which was propitious for him. And just a snap of his fingers could do it, even if every single other MP was against. So although we can still have early elections, it's not as easy as it was. All right, so that is just a very curt introduction to royal prerogative. Toodaloo.